the Beothuk, Inuit, Innu, and Mi'kmaq and their ancestors were the first peoples of Newfoundland and Labrador. Livyers, settlers, and visitors from Europe have a lot to answer for at every level of society: government, business, professions, trades, and laborers. The law, which judges, lawyers, others in the justice system, and the public respect, has been described by one of the well-known legal historians as the perfect instrument of empire. We are thankfully in the process of reconciliation and have much work to do in cooperation with our Indigenous neighbors, so let's work together. So there's one more announcement to go before we get started.
The actors, writer, co-directors, your immediate neighbors, and the rest of the audience expressly and by necessary implication requested that you turn off your cell phones and tablets. No photography or recording. An archival recording will be available on request at no cost for personal use. Thank you.
Name is Codner. Codner Bickfield. And I am the crier in the Supreme Court of Newfoundland. You crowd, I am told, are a lot of hang-shores. You're on a little time-traveling jaunt. Believe me, I know, I've read my Jules Verne. And I know that you lot, you're nothing but a bunch of trouble. Idleness being what it is and all. And a belly full of wine. And hot food. No doubt, oh God, there is a recipe for trouble for you. I want no trouble from you lot. Or else there's going to be contempt of court charges on all of you. So mind yourselves. Here we are, a little over 75 years ago, from your time back to today. It's December 6th, 1948. This is the day when the Supreme Court of Newfoundland, in the person of Mr. Justice Brian Dunfield, hears the case of Currie versus Macdonald. If you want my opinion, you probably don't, but you're going to get it anyway. There is too much emotion in all of this. All of them are so fired up and personally involved. Whoever heard of it? Lawyers. All fired up about something other than money, eh? Mine's not normal. So, look, in April of last year, 1947, we had Emerson and Cashin. This was judges of the Supreme Court, Chief Justice Sir Edward Emerson, and Mr. Justice Harry Winter, and his brother, J. Alexander Winter, registrar of this court, no less, suing Major Peter Cashin for slander concerning Cashin's remarks during the National Convention. He said that they were part of a conspiracy to bring about commission government in the first place, and that the Brits had told them that they would be looked after. Well, Cashin used the words bribery and corruption, and that was it. Into court with a lot of them. Cashin got off by the skin of his teeth, and a fine speech to the jury. Nothing but pride and emotion in that one. Here we go again. So I bet half of you are too green to burn and don't know what it's all about anyway. So I'll give you a thumbnail sketch, just to keep you in the picture. Counsel. Counsel in this case are Robert S. Furlong, Casey, and Jim Power. Two professional Catholic bachelor corner boys, if ever there were two. Furlong down at Amara's drugstore on Rawlings Cross with Mullally and O'Neill every Sunday after Mass. And and Jim Power lounging in Dr. Jim McGrath's parlor all the time for an amiable whiskey or rum or whatever was on the go. Sure, you know that Ms. Harris will never get our Furlong to the altar. No. She's got about as much chance of that as Aggie O'Day has of doing the same with Jim Power. And besides, those women are too smart for that. They both know that the score with these two, they're far better off with the conversation and the companionship without the laundry and the other thing. You know what I mean? So as for Furlong and Dunfield, well, everyone knows these two, they're two for a cockfight, right? Let me put it this way, they're not very fond of one another. And what with Dunfield, this Dunfield, as head of the St. John's Housing Corporation, expropriating the land of Furlong's clients for the Churchill Park housing development, and then Dunfield as judge, glaring down at Furlong from the bench of this court. Oh, that is not a pretty sight. And then there's Jim Power. Well, he's an affable fellow. Only too willing to have the government's brief opposite Furlong, particularly with Dunfield on the bench. Now, here in the fall of 1948, preparations for Confederation are all underway. In the second referendum, a little over 52% voted for it. Delegation of Newfoundlanders, appointed by the governor, are negotiating the terms of union at this very moment, and they have been at it for some time now. And meanwhile, the responsible government crowd has one more fight left in them. This case. The plaintiffs, they're all from the last Newfoundland Parliament, 1934. 3 of them were from the last Legislative Council. John Currie is the publisher of the Daily News. John O'Day and Frank McNamara, they're St. John's businessmen. The other 3 plaintiffs are former members of the last House of Assembly. W.C. Windsor's a famous sealing skipper, Harold Mitchell's a World War I veteran, and founder of the Great War Veterans Association. And William J. Brown is a Rhodes Scholar, a lawyer, a sitting district court judge, no less. Brown's involvement in this case will come back to bite him later on. You mark my words on that. Well, the defendants are the governor, Sir Gordon Macdonald, who was a Welsh coal miner, if you can believe it, and a British Labour politician. Well, the 3 commissioners were civil servants. The Newfoundland commissioners are Herbert Pottle, a teacher, Herman Quinton, a World War I veteran, and Albert Walsh, a lawyer. So the lead lawyer for the plaintiffs, Robert Furlong, apart from the codology I was going on with a few minutes ago, Furlong has a reputation as a very fine barrister. He's got a quick retort as needed. And with a little luck, he may be a judge himself one day. While everyone knows that Jack Higgins did the pleadings and is the brains behind the case, Furlong is the man for the court work. He's got with him R.A. Parsons, World War I veteran and poet, no less, Ed Phelan, and T.P. Halley. Catholics, Protestants, war veterans, you know the drill. The lawyer for the defendants, all by himself, is Jim Power, the Assistant Secretary of Justice. His eminence, Mr. Justice Brian Dunfield, has been on the bench of the Supreme Court for almost 10 years and will likely be there for some time to come. He comes complete with a lisp and one of those Atlantic English accents that some of the fine people pick up strolling along Circular Road. What? Here goes. Oh yay, oh yay, oh yay, all manner of persons citizens having anything to do before the Supreme Court of Newfoundland, draw near, give your attendance, and you shall be heard. God save the King and the King's judges. The case of Currie versus Macdonald. Who appears?
Robert S. Furlong for the plaintiffs, my lord, and appearing with me are E.J. Phelan, KC, R.A. Parsons, KC, and Thomas P. Halley.
James Power for the defendants, my lord.
Well, Mr. Furlong, begin.
Thank you, my lord. And of course, I mean lord in a gender-neutral manner. This case is of the utmost importance. The very existence of Newfoundland as a sovereign, independent member of the Commonwealth hangs in the balance. The constitutional law of Newfoundland, the United Kingdom, and the Commonwealth has suffered a mighty blow, which this honourable court must set right. For 100 years, Newfoundland had democratic assemblies. December 31, 1832 was the date of reception of English statutory law, and that reception of law started Newfoundland on its way to elected Newfoundland parliaments. From Cabot's landfall in 1497, British constitutional law and the common law, those great unwritten bodies of custom and convention, hung like a stout, if sometimes leaky roof, apropos of our weather, over the head of each and every British subject resident here. The principles of British constitutional law, as they evolved through the centuries to the establishment of this court in 1824, to representative government in 1833, to responsible government in 1855, to the Statute of Westminster in 1931, protect every British subject, and that law now requires that this court protect the rights of the citizens of Newfoundland. Who comes before you? Why, the citizenry of Newfoundland, as represented in the persons of the last members of its parliament before dissolution: Currie, O'Day, McNamara, Windsor, Mitchell, and Brown. If there was a need, many more might have appeared: Winter, Shea, Fury, Eyre, Whiteley, and Halley, to name a few more from the last House of Assembly.
Mr. Furlong, the only one withstanding to bring this matter is the Attorney General. Where is he in this statement of claim? At the very least, where is his letter of consent for these formerly honorable, but now very ordinary and common citizens to bring this matter to this court?
Do you ask the fox, my lord, to guard the chicken house? Dante, my lord, in his journey through the 9 circles of hell, saw the places where the narrators were plunged in boiling oil and guarded by demons, armed with prongs, and where the hypocrites, the thieves, and the fraudulent council, my lord, were clothed in the flames that burned them.
You go too far, Mr. Furlong.
Well, your question distracted me from my purpose, my lord. I returned to the narrow road, as if I could stay on any narrow road, but I digress. The true path: 6 members of the last Newfoundland Parliament.
Why only 6, Mr. Furlong? Were you trying to make up a dozen eggs and only able to get halfway around the hen house?
Now you go too far, my lord. 3 are from the last Legislative Council, and 3 from the House of Assembly of the last Newfoundland Parliament. Hardly nobodies, with no leg to stand on. Who else stands behind this action? Why, just about the entire Law Society. On February 9, 1948 passed, all signed a petition, all, in support of principles set in this action. That petition went to the Secretary of State for Commonwealth Relations, and it stated, in part, that the law setting up commission government, and I quote, provided specifically that Newfoundland's constitution would be merely suspended and would be restored to the people at their request when the country again became self-supporting. We consider that no irrevocable decision as to union with Canada should be made without prior full examination by a Newfoundland government and its financial and economic advisors, and after detailed and exhaustive negotiations between governments. 32 lawyers, men and women, signed that petition, including myself and the 3 other learned counsels sitting at the plaintiff's counsel table.
Do you not feel lonely, Mr. Power, over there all by yourself?
Yes, my lord. Like Ulysses before the sirens, Mr. Furlong's argument and his companions are not nearly so attractive or persuasive as those Grecian women. They are undoubtedly, though, just as dangerous.
Well, sirens, it is to be noted, did accord Ulysses standing to be heard. The plaintiffs, representing the last Newfoundland Parliament and the people of Newfoundland, bring this action. But what is their plea? The Newfoundland and British Parliaments both promised to restore responsible government, just as it existed in 1934, as soon as this country, Newfoundland, became self-supporting. The Finance Committee of the National Convention confirmed Newfoundland is now self-supporting. The citizens of this country, this Dominion, Newfoundland, voted, and their elected representatives to a national convention which studied the issues for almost 1.5 years, for over 16 months, for over 70 weeks, for 506 days, and then voted in favor of holding a referendum with only 2 choices on the ballot. 1, continue with commission of government, or 2, return to responsible government. That was the voice of the people. Therefore, it was illegal, crime, and improper for the commission government to do anything to impede the return to any form of government but responsible government. The British Parliament, too, was bound by its act, the Newfoundland Act of 1933. The British Parliament legislated itself to be the trustee for Newfoundland people, while the Act suspended Newfoundland's constitutional parliament. The Commission's duty was to enable the return to responsible government, and to do nothing which might lead to any other result. His Majesty's Dominion of Newfoundland has been self-supporting since the year 1941. The Commission of Government had a legal duty to seek the restoration of responsible government. The Commission, in breach of this duty, has failed to do so since 1941.
1941. It's now 1948. Are you not a little late with this statement of claim, Mr. Furlong?
Your lordship cannot possibly be comparing the plaintiffs to Lewis Carroll's March here. We have here not an application for a prerogative writ to quash an administrative or quasi-judicial decision. We have here, my lord, a matter of constitutional law, the case of an ultra vires act, a nullity. I lost my page. Thank you. Too big a nullity. Time cannot run against a nullity, of course. While you may have a rabbit or a snowshoe here for your supper and determine whether or not it's late, either as a guest or the main course, you cannot put a time limit on a nullity. The National Convention met on September 11, 1946, considered these matters, and on January 30th, 1948, recommended that 2 forms, just 2 forms of government, be submitted to the people of Newfoundland in a referendum: responsible government or commission government. The National Convention of elected officials itself defeated a resolution to recommend that confederation appear on the ballot by a vote of 29 to 16. 29 to to 16. Contrary to the elected National Convention's findings, reports, and recommendations, the unelected Commission government included confederation on the ballot paper submitted to the people, giving effect to a decision of His Majesty's government in the United Kingdom, and failing to exercise its, that is the Commission's, independent judgment. As we know, the result of the first referendum by percentage was responsible government 45%, confederation 41%, Commission government 14%. The result of the second referendum was confederation 52.4%, responsible government 47.6%. Plaintiffs will suffer, by confederation with Canada, a change, socially, economically, and politically. Above all, however, in common with the people of Newfoundland, the plaintiffs will be seriously affected, first, in their allegiance and national status and citizenship. Second, in their loss of control of their fisheries and other resources, industries, and services, such as airports. And thirdly, in that as Canadian citizens, our per capita debt will rise from about $100 to over $1,000 for each man, woman, and child in Newfoundland, without any compensation fund to account for this mandatory donation to Canada. My lord, the plaintiffs have no guns, no army, no navy, no infantry divisions to call a halt to this treason, nor is there any international court to hear our appeal. We must rely on you, my lord, and this court to hear our petition. No, our cry for justice and democracy. Over 100 years of independence will die if this court turns its back on us. When C.J. Burchell, the emissary and agent of Mackenzie King, arrived in St. John's in 1941 to take up his position as Canadian High Commissioner to Newfoundland, we watched in amusement at his efforts to identify and enlist the support for confederation with Canada. On March 11th, 1948, however, fear and apprehension seized us when Britain rejected the 29-16 majority recommendation of the elected National Convention not to include confederation on the ballot, and rejected the opinion of 90% of the members of the Newfoundland Bar that confederation should be left to the first elected House of Assembly of the Dominion of Newfoundland following an unelected Commission government. Was not this a breach of the trust, the sacred trust, that the British Parliament undertook in 1933? A famous Chief Justice of this land said, and I quote, "We judges first make up our mind on what is fair and just, and then proceed to find reasons and ways to justify our intuitive feelings in a written decision of the court." My lord, first you have to ask yourself what is legal and constitutional. Not what is legal and constitutional, but what is fair and just, what is right, what is moral. Could it be fair and just that Commission government assists the British Parliament in breaching this trust to guard Newfoundland's constitution and its right to an independent Parliament? If the governor and the commissioners succeed in pushing through confederation, they will have murdered a dominion. Could it be fair and just to allow the unelected Commission government to ignore the elected National Convention's vote to exclude confederation from the ballot? Could it be fair and just to give effect to the muddled referendum campaigns and the equivocal and marginal vote of the second referendum? I say, my colleagues say, the elected National Convention said, the people say, the Newfoundland Act says, the Constitution says, the people and the law, yes, the law, say this cannot be. We await your decision, knowing that whatever your ruling, my lord, it will be forever in our Newfoundland law reports. In 50, 75, or 100 years, members of the Newfoundland Bar will read and study your decision and ask themselves, was he not only legally and constitutionally correct, but was he morally right? Let me conclude with the words of a great Englishman, John Chadwick, who lived here for many years, who said, Newfoundland has too much of history, or rugged obstinacy, or native character to ever lose her true identity. Let it never be said that this court, that this judge, with a stroke of his pen, swept that history, that rugged obstinacy, that native character, that true identity, swept all that aside forever. History, my lord, can be the most unforgiving judge. Fairness and justice cry out for a finding in support of Newfoundland, Newfoundland's parliament, and the people of this great country.
Mr. Power, I believe Mr. Furlong has just concluded his submission. What do you have to say about the matter?
Thank you, my lord. The application before the court is one requesting that you find that the statement of claim does not disclose any reasonable cause of action, that it is defective in substance, cannot be corrected by amendment, and that you should dismiss this action as frivolous and vexatious. The action is defective at every count. The plaintiffs have no standing. They have delayed too long in bringing the action, and they must certainly fail on the substance of their allegations and the remedies which they seek. First, who are these plaintiffs? My learned friend suggests that they represent the last Parliament of Newfoundland. Well, Currie, O'Day, and McNamara were, and I stress were, members of the Legislative Council in 1934. Windsor, Mitchell, and Brown were, and I emphasize again the word were, members of the House of Assembly. But they are no longer. These honorable gentlemen are only the same as you and me, ordinary British subjects of His Majesty the King who reside in a British colony. They have established no special interest, nor can they claim that they will suffer any special injury or harm. In any event, my lord, an action such as this one requires the consent of the Attorney General. My learned friend has not pleaded anything concerning the Attorney General, except perhaps that he regards him as a scoundrel. He has dressed the plaintiffs up as lambs, when in fact they are merely mutton. He has put words of grievance and harm in their mouths. He claims that they, in common with the people of Newfoundland, will be seriously affected in their allegiance, national status, and citizenship. Indeed, the very pleadings in this case do not distinguish the plaintiffs from the rest of us. Put another way, he has dressed the plaintiffs up as veal, when in fact they are merely bulls. And a soaring lot of old bulls at that. And all of what they've said is, well, the stuff that comes from the rear end of a bull. And I'll leave that to your imagination.
Do I sense, Mr. Power, that you are invoking Shakespeare and his Danish Prince Hamlet, as Mr. Furlong brought Dante to his aid in a similarly misguided misadventure earlier in this proceedings?
How so, my lord?
Why, Mr. Power, let me see. How does it go? Yes. I'm sure you will recall Prince Hamlet speaking at the graveside of some poor fellow whose skull the comic gravediggers negligently unearthed in their recklessness. Hamlet at that point asked, "May it not be the skull of some lawyer? Why, that same box there would scarce hold the conveyance of his land. Must his body lie there? Oh, pitiful transformance! Is parchment made of sheepskins? In faith, they prove themselves sheep and calves that put their trust in them or deal with them." I'm sorry, gentlemen, I digress. My apologies.
Well said, my lord. The plaintiffs simply have no standing and no right to be in this court, whether lamb, mutton, veal, or bull. Timing, my lord, like in many aspects of life, is everything. My learned friend pleads that Newfoundland's finances and her economic circumstances had recovered by 1941. I do not recall my learned friend beating on the doors of this court to seek admission at that time, nor, my lord, at any time in the long 7 years from 1941 to 1948. The plaintiffs cannot sit on their supposed rights. They cannot wait and see how they would do in the National Convention and the referendum, fully expecting to carry the democratic debate on the future of the government of Newfoundland. The progeny that will hatch from that 7-year-old egg can only be grotesque and unwholesome.
Mr. Power, you have graphically made your point on standing. Your barnyard metaphors engage the senses, sight, hearing, and particularly smell.
Thank you, my lord. I'll now turn to the substance of the plaintiff's claim. I am sure that a learned gentleman such as yourself, my lord, will have noticed that my learned friend has not cited a single legal case in support of his position. As you know, my lord, learned counsel opposite is well known for his ability to write and his thoroughness in combing through the law reports. It is often said that a barrister who comes to court with a single case is a dangerous man. My learned friend, however, has come to court empty-handed. He may wish to be disarming in his manner and argument, but he appears before you not disarming, but disarmed. He can cite no, and I repeat, no legal case to support his position. Now, this court, not so very long ago, in March of 1946, in the considered 30-page judgment of Mr. Justice Fox in Dillon versus Canning, beginning at page 386, reviewed the constitutional legal principles that apply to commission government. The matter is settled law. Justice Fox concluded at pages 407 and 408 that the governor, with the advice and consent of the Commission of Government, and I quote, my lord, acts with full constitutional and executive authority and takes the place of the legislature and executive council as existed under responsible government in this country. Elsewhere in his reasons, Justice Fox's language is even more certain, perhaps even excitable. He uses phrases such as clear beyond cavil, patent, undoubted, unequivocal, unqualified, free from even a scintilla of doubt, and unmistakable in meaning and intent. Sure, you can practically see Judge Fox bouncing up and down and pounding his fist on the judge's bench to drive home his point. What could be more plain than that?
The images of Justice Fox bouncing anywhere and pounding anything staggers the imagination. The idea is unthinkable of him or of any of the reserved and dignified judges of this court, past or present.
Might I point out, my lord, in concluding my remarks on the Dillon case, that Furlong KC and T.P. Halley, two of the counsel opposite, were among the learned losing counsel in that case.
You've made your point, Mr. Power. Move on.
Certainly, my lord. In some instances, the courts have allowed a plaintiff to sue a colonial governor for personal liabilities. Personal liabilities. There are some examples in the cases. For wrongfully arresting ships in Jamaica, for failing to pay his London jeweler when he ruled Trinidad, for banishing a rioter from Majorca, or for unlawfully detaining a person in Gibraltar. However, when it comes to dragging the colonial governor into court in the exercise of a legislative or public duty, which affects the whole of the population, my learned friend Mr. Furlong can produce no case. But, my lord, there is something far more fundamental involved in this case. In some respects, much of the argument today concerning standing, delay, and the fine principles of constitutional law is all legal quibbling. The people of Newfoundland, at the heart of this matter, are the only body entitled to claim the performance of that alleged promise, namely the restoration of responsible government. The people, however, with the only voice they have, the voice of the majority, have dispensed with that promise. They have said they do not wish it to be carried out. They would prefer to have something different. Confederation with Canada on the terms put before them. Now, what the plaintiffs have tried to set up is that they, the minority, can call for the performance of that alleged promise when the majority do not wish it to be performed. That they, the minority, can insist that the people return to responsible government against the people's expressed wishes. The plaintiff's argument amounts to saying that the will of the people cannot be ascertained through a referendum. But what better way could there be? A referendum must give a clearer view of the will of the people than a general election. It gives every man's vote an equal weight. In elections, the clear issues tend to be confused by the personal claims of candidates and by other issues. How could it ever have been discovered whether the people did or did not desire the abolition of commission government and the return of responsible government, except by holding a referendum? And as for putting confederation on the ballot, 50,000 Newfoundlanders signed a petition to include it. 50,000, my lord. That is democracy. And that is more important than 32 lawyers signing a telegram.
That's my book.
And the only right of the individual citizen that I can see is the right to put in his little contribution, his one vote towards the general decision. He does not have the right to stand in the way of the majority. He does not have the right to prevent them from having their chosen form of government. And he certainly does not have the right to get this court to interfere with that decision. There is no magic formula which will enable a minority to defeat the majority. If a majority has the right to demand at law the carrying out of an alleged promise, surely the majority can have a right to dispense with that promise. Lord, I make these observations on the logic of the plaintiff's arguments rather than on the law. After all, the law is usually logical. In this instance, both law and logic are one. My lord, those are my submissions. I now leave this most important decision in your hands. Thank you.
I'm going to adjourn these proceedings to consider your arguments, gentlemen, and I call on council to attend here in exactly 1 week on December 13th, and I will then deliver my judgment in open court.
Oh yay, oh yay, oh yay, let all manner of persons having anything further to do before the Supreme Court of Newfoundland depart hence. Give your attendance again on tomorrow at 10 o'clock in the forenoon, and you shall be heard. God save the King and the King's judges. So, here we have the argument finished on December 6th, 1948, and well, on December 11th, the terms of union were signed in Ottawa. 2 days later, on December the 13th, Dunfield returned to open court to render his judgment. But while Mr. Justice Dunfield wrote his decision, the world continued to turn. Timing, ladies and gentlemen, sometimes is everything. Now, as soon as he compiled himself into his judicial robes, oh yay, oh yay, oh yay, let all manner of persons having anything to do before the Supreme Court of Newfoundland draw hence, give your attendance, and you shall be heard. God save the King and the King's judges.
This purports to be a constitutional case, and we cannot deal with it in the rarefied atmosphere of the law, separate and apart from the facts. Constitutional law in non-federal British countries, like the so-called international law, is, for the most part, not law at all, but a system of customs and conventions which the court does not enforce. And it deals with the distribution of that ultimate reality, power, which is above both courts and nations. If I may put it somewhat metaphorically, Leviathan can be bound only with ropes of steel, and the attempt to bind him with gossamer webs of words lacks reality. Next, who are the plaintiffs in this case? They are 6 citizens, differing in no way from other citizens. They observe that they were members of the last Newfoundland Parliament, but ex-membership in a parliament defunct for 15 years does not give them any special status. I know of no precedent for a case where ordinary citizens take leading legal proceedings against their legislature in respect of legislative acts, nor has any been cited by counsel. But the ordinary principle in a case of complaint of excess of authority against a public body is that those complaining must show themselves to be, as individuals, peculiarly injured over and above citizens generally. But the plaintiffs do not show that. On the contrary, they proceeded simply as citizens. It appears to me that they have no right to proceed, to set themselves up as representing any part of the public. The protection of the public generally is a matter for governmental authority, and specifically for the Attorney General. It would seem to me that there exists in the minds of the local public certain hazy and erroneous notions about constitutional law, and these may possibly be shared by the plaintiffs. This may be due to the reading of a good deal of American literature. The British Empire, however, is a unitary state with one supreme legislature, the King, Lords, and Commons, and no written constitution. New Zealand is unitary. Newfoundland is a subordinate unitary, like many other overseas territories. And in these cases, the supremacy of the legislature is the central principle of law. The imperial parliament is supreme in the empire, subject to the observation that in the case of Canada and some other dominions, it has, by Statute of Westminster, abdicated the right to legislate for them without their consent. Other unitary legislatures in the empire are still subject to the overruling power of the imperial parliament, which could abolish anything from the Magna Carta downwards. What is called constitutional law under that system is a mass of conventions and customs which are not law. I have listened to counsel at some length, but this statement of claim is a dead horse, and flogging it will not bring it to life or make any difference to the plaintiff's position. The action is based on fundamental errors of law and logic, which are apparent on the face of the papers, and which are fatal to it, no matter what counsel might say. Legally, logically, and practically, it seems to me to be nonsense. I've gone into the case at some length because it deals with matters in which the public is interested and concerned. And I think the public should have a chance of understanding what the court is doing and why. The law should not be made a mystery to the average person. If I were speaking only for lawyers, I should have been more summary. The action is hereby dismissed as frivolous and vexatious. Accordingly, I strike out the whole of the statement of claim. The defendants are to have judgment with costs to be taxed.
Oh yay, oh yay, oh yay.
You should stand, I think.
Let all manner of persons having anything further to do before the Supreme Court of Newfoundland depart hence and give your attendance on tomorrow at 10 o'clock in the forenoon, and you shall be heard. God save the King and the King's judges. In concluding this case, and just before you lot get to ask a few questions and make some comments, I'm going to entertain you with a piece of doggerel, which is from the humorist Canon George Earle, who wrote satirizing the Gothic rhetoric of our own Joseph R. Smallwood on the subject. You chuckle-headed, muddle-headed, miserable wretches, the shame of 1948 will bring eternal stretches of punishment and misery to everyone who gloated that Newfoundland could stand alone and canvassed, lied, and voted. You hypocrites from sepulchres, so glamorous and whited, ye sutters of a former age with prejudice so blighted, you mortal sinners of this isle, both liberals and Tories, you in your ignorance and sin told endless lies and stories. Look at your present jobs and checks and feel your greasy pockets. Your eyes should shut with guilt and shame and vanish in their sockets. Should not the senior citizens, the unemployed and kiddies, you nearly robbed of benefits, now give you all the ditties. The only way to clean your graves and rectify your blindness is by a public penitence and public acts of kindness. On all the outport roads and lanes and pavements in the city, and gaze at children all around with tenderness and pity. And don't put on your Sunday best or uniforms with sashes, but wrap yourself in dirty sacks and slob yourselves with ashes. So to your knees in sackcloth now, seek pardon from your nation, and grovel for the vote you cast against confederation. I am sure that the responsible government crowd could, and probably did, come up with something similar. In fact, they did. They did. On the departure of Governor Gordon Macdonald, some clever townie hack wrote a piece of verse supposedly singing the praises of the honorable gentleman. Later, everyone realized that it was an acrostic. The first letter of every line down the left side of the page spelled the bastard. So, to bring us to the final stage of the evening, I will add my own verse. Now, we turn to hear from you what questions you may have. With cast and crew and all of you, whatever you may dare, the answers though may stuck the timid and the brave, the history buff, the townie tough, like a tidal wave.